Good morning, everybody. My name is Pranav, a legal intern at LEXIS and Company for the month of June. And today in legal news, voluntary gifts given by parents, friends to bridegroom out of love and affection, not dowry. It was held by the Calcutta High Court. The court ruled that while dowry as a quid pro quo for marriage is prohibited, giving of traditional presents to the bride or the bridegroom by friends and relatives is not. The Calcutta High Court has ruled that voluntary gifts given by relatives and friends before or after the wedding to the bride or the bridegroom and which are not given as considerations for marriage but out of love and affection will not fall within the definition of dowry under the Dowry Prohibition Act. This was held in the case of Nethai Ghosh v. State of West Bengal. Justice Bibek Chowdhury ruled that while dowry as a quid pro quo for marriage is prohibited, giving of traditional presents to the bride or the bridegroom by friends and relatives is not. The court said that voluntary presents given at or before or after the marriage to the bride or the bridegroom, as the case may be, of a traditional nature, which are not given as a consideration for marriage but out of love and affection or regard, would not fall within the mischief of the expression of dowry, made punishable under the Act. The court therefore acquitted the husband of the deceased and his mother in the dowry death case against them. The court was hearing an appeal filed by the accused against a judgment of the additional sessions judge at Barasat, convincing them of offences under sections 498A, which is husband or relative of husband of a woman subjecting her to cruelty, and section 304B, that is dowry death of the Indian Penal Code. The case stemmed from a complaint of dowry death filed by one Mr. Nirmal Ghosh regarding the death of his daughter, Soma. He stated in his complaint that Soma had committed suicide due to physical and mental torture for dowry inflicted upon her by her husband Nethai Ghosh, mother-in-law, and one Shankar Ghosh, who was the husband of Nethai Ghosh's sister. The complaint stated that at the time of marriage, Nirmal Ghosh had given bridal presents as per his financial capacity. It was decided before marriage that he would also give a gold chain to the accused within 6 months of marriage. However, immediately after the marriage, the husband, his mother, and his sister of the husband started abusing her. It was also stated that she was subjected to physical assault. On August 4, 2011, the complainant came to know that Sona had died by consuming poison. Based on the complaint, the case was registered for offences under section 498A and 304B. The trial court held the appellants guilty for committing offence under section 498A and 304B of the Indian Penal Code mainly on the first grounds. First, the witnesses on behalf of the prosecution cannot be disbelieved only because they are closely related with the deceased, and all the witnesses stated that the deceased Soma was tortured by the appellants both physically and mentally, demanding the gold chain. Second, the deceased had met with an unnatural death within 44 days of the marriage. And third, the defense had failed to prove its case. In appeal before the High Court, it was pointed out by the counsel for the accused that the complainant had never alleged about any demand for dowry by the accused. Some bridal presents were given by the complainant, and the presents given by the parents at the time of marriage do not come within the definition of dowry under the Dowry Prohibition Act. It was also pointed out that witnesses who attested to torture of the deceased by the accused were all closely related to the deceased and very much interested to see the appellants convicted and sentenced. The counsel for the accused submitted that if a married lady is tortured both physically and mentally at a matrimonial home, neighbors residing around the house of the accused persons are natural witnesses who would know about the incident. The prosecution failed to bring any neighbor of the matrimonial home of the deceased. The accused persons also took the defense that the deceased Soma was very ill-tempered and had illicit relation with the husband of Nethai Ghosh's sister. The state rebutted the submissions, arguing that in cases of torture arising from matrimonial relations, harassment generally happens in the secrecy of the house and it becomes very difficult for the prosecution to leave the evidence. The state counsel further submitted that no other member of the family, even if he is a witness of the crime, would come forward to depose against another family member. The neighbors, whose evidence may be of some assistance, are generally reluctant to depose in court as they do not want to antagonize a neighborhood family. He further submitted that if a woman after a marriage is tortured, humiliated, and harassed for dowry, the lady will naturally narrate such incident to her parents and other close relations. He further argued that considering the small time gap of only 44 days between the solemnization of marriage and the date of death, the trial court rightly applied the presumption of law under section 113B of the Indian Evidence Act. After examining rival contentions, the court proceeded to examine the scope of the term dowry contained in section 2 of the Dowry Prohibition Act. The court noted in its order that the legislature has, in its wisdom, while providing of the definition of dowry, emphasized that any money, property, or valuable security given as a consideration for marriage before, at, or after the marriage would be covered by the expression dowry. The definition cannot be merely applied to demand of money, property, or valuable security made at or after the performance of marriage, the court had stated. The court also stated that, thus, any demand of money, property, or valuable security made from the bride or her parents or other relatives or relatives by the bridegroom or his parents or vice versa would fall within the mischief of dowry under the Act where such demand is not properly referable to any legal recognized claim and it is relatable only to the consideration of marriage. The court also held that voluntary presents given on or before before or after the marriage to the bride or bridegroom cannot be considered dowry. In this regard, reliance was placed on the Supreme Court judgment in LEXCLIQ Reddy v. State of Andhra Pradesh. In the instant case, the court noted that the complainant had himself said that he had voluntarily given bridal presents according to his capacity. It was decided that he would also give a gold chain after 6 months of marriage, and then the said 6 months had not expired, and within 44 days after the marriage, the deceased met with an unnatural court. The court noted that, under the facts and circumstances of the case, it is absolutely natural and probable that when a married lady is tortured at a matrimonial home, immediately after the marriage, the near relatives of the lady would intervene and try to settle the dispute. There is absolutely no evidence prior to death that the witnesses and others tried to settle the alleged dispute between the parties during the lifetime of Soma. The court further said that there was some evidence that Soma was ill-tempered, and the judgment finally said that, therefore, if at all any incidents of quarrel broke out between the appellants and Soma, here the nature of Soma was not such that she would silently digest the allegations made against her. Further, the court also said that the report of the autopsy surgeon showed that he was not in a position to give his final opinion as to the cause of death before receiving the chemical examiner's report of the viscera of the deceased. Based on the above grounds, the court set aside the order of the trial court and acquitted the accused. With this, I come to the end for today's discussion. Thank you.